Welcome students, former students, colleagues, members of the Copyright Bar. Thank you very much for coming to the 36th Annual Horace S. Manges Lecture. You should have a program, and because we have a fully packed lecture, I am not going to read you all about Horace Manges or our esteemed speaker, but I'm just going to say that Horace Manges, a founding partner of the firm of Weil, Gottschall, and Manges, was a titan of the copyright bar in his day, and the Horace S. Manges Lecture and Conference Fund was established by his law firm in his memory, and is the Horace S. Manges Lecture and Conference Fund brings us every year this is prestigious lecture and the nice reception that will follow in the Case Lounge. So I'll announce that now. We'll not need to announce that later. Our speaker, is a great pleasure to have Dale Cendali be the 36th Annual Horace S. Manges Lecturer. She is the head of Kirkland & Ellis's Copyright, Trademark, Internet, and Advertising Group. And to keep it short, I will simply say that she is the premier litigator in the field. It is really an extraordinary honor to have her here. So many of the cases that I talk about in copyright class, including this morning, are cases that she brought and generally won. So it's great to have you here, and I will not take up any of more time so that you can use up as much time as you need. Thank you so much.
All right. Thank you. Hello, everybody, and thank you for coming. Before I begin, I'd like to give my sincere thanks to Columbia Law School's amazing Kernighan Center, in particular to the amazing Professor Jane Ginsberg and to the Executive Director, Pippa Longard, for selecting me to give the Manges Lecture this year. I've always looked forward to the Manges Lecture as a highlight in the year of copyright, and I will do my best to follow in the proud tradition of my predecessors. Tonight's topic is litigating fair use. What I'm going to talk about is how a litigator not only tries to win a case, but in so doing can help shape the development of fair use law. So fair use is well recognized as one of the most unpredictable doctrines in copyright law. We're all aware of the many famous cases where the district court wrote a compelling opinion holding that something was or wasn't fair use, only to have a court of appeals in an equally certain sounding opinion take the opposite point of view. Sometimes we've seen the Supreme Court take yet another view, or multiple views where there's a dissent and perhaps a concurrence as well. Court after court has noted that fair use requires case-by-case analysis that carefully balances the four statutory fair use factors, perhaps sometimes some other considerations as well, rather than rigid application of bright-line rules. The overall intent is to help judges reach a result that furthers the bedrock constitutional principle that copyright laws promote the progress of science and the useful arts. The flexible nature of fair use provides an opportunity, and sometimes a challenge, for the copyright litigators to not only figure out how to apply existing precedent to create a persuasive argument, but also to invite the creation of new precedent. Copyright law and fair use specifically starts from Congress's statutory text, is informed by the Copyright Office's guidance, is interpreted by the courts, and is analyzed by law professors. But litigators are not passive in this process. Rather, they play an important role as well. In fact, The modern litigator is often in a uniquely good position to affect the development of fair use. These days, litigators practice all around the country with admissions in many courts and pro hac vice applications in others. This cross-country practice creates the opportunity, in fact, the opportunity to keep abreast of trends and splits in the various circuits, to figure out what best to argue in a given case, and thereby to hopefully advance the law and their clients' interests. Simply put, if the law of fair use is developed by case precedent, then the people whose arguments impact cases, that is litigators, can help shape the law. How do litigators do it? In this lecture, I will discuss 3 of the primary tools of the litigator's proverbial toolkit: law, facts, and especially persuasion. At the end of the day, these 3 things determine every fair use outcome. The art of litigating fair use is found in the gaps between precedent, when your cutting-edge case is one about which reasonable minds may disagree. It's in those gaps where the litigator shines, because the law there is at its most malleable, and the ability to persuade is most important. And with fair use, there are a lot of gaps. Tonight, I will explore the litigator's arsenal, moving from law to facts to persuasion. Persuasion will be the most fun part, I'm warning you. Using some of my own cases to illustrate each part. And finally, I'll conclude with what I see as some of the next great big issues in fair use from my position in the trenches and how litigators may help resolve them. So without further ado, I turn to the litigator's first weapon, understanding the law of fair use and especially its malleability. I will discuss a small slice of legal history on just one aspect that I hope will show how litigators not only understand the law, but have an opportunity to affect its development. Now, to make sure we're all on the same page, because at least one person asked me, what is fair use law, as we went into this, let's start with the statute. Section 107 of the Copyright Act is the fair use provision. It begins by describing the types of uses that may be fair use and thus not an infringement of copyright law, and then lays out 4 non-exclusive factors that a court shall consider in addressing fair use. I think it's fair to say, however, that perhaps the most significant, no pun intended, that perhaps the most significant development in fair use law over the past 30 years came not from Congress, but from the courts in the form of the transformative use doctrine. First proposed by Judge LaValle in a seminal Harvard Law Review article, transformative use was adopted by the Supreme Court in 1994 in Campbell versus Acuff Rose. There, the court held the first fair use factor, which considers the purpose and character of the use, asks whether a use is transformative. As the Supreme Court explained, that means the first fair use factor looks to whether the new work merely supersedes the objects of the original creation or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. Litigators in courts ever since have grappled with what this means in practice. I think a few law professors have too. I remember reading almost all of your articles on this subject, and many of you are here today. Some courts took a broad view of transformativeness and essentially found that any work that added any new expression was transformative. In these cases, such a finding often had a domino effect on the other factors. This litmus test approach to fair use led to an overall conclusion of fair use whenever transformative use was found. Other courts, however, were less keen to find transformative use or were less likely to let it alone dictate the result. The problem with the all-or-nothing approach, leaving aside the possible reduction of the other factors, is that it runs headlong into the question of where the derivative work's right ends and where transformative use begins. Section 106 of the Copyright Act grants to the copyright owner the exclusive right to prepare derivative works, that is, to prepare works based on the original and any other form in which a work may be recast, transformed, or adapted. How transformed derivative works differ from transformative fair uses, Campbell doesn't say. Courts began noting this tension in various ways over the years, and it became increasingly a subject of discussion, especially after the Cariou case, which I'll touch on in a minute. But this tension was not noted just by judges. It was also written about in law reviews and discussed by bar associations. And turning to the role of litigators specifically in this conversation, litigators contributed in various ways. Most directly, litigators contribute to the development of fair use law by making arguments in their own cases, whether in briefs or oral argument, leading to the judicial opinions we all love to discuss. As I noted, though, this involves closely keeping abreast of precedent and figuring out how to tease out language and nuances that might be persuasive to win a case for their clients. But the U.S. also provides an opportunity for even people not directly involved in a case to provide their views. And this is a particularly useful tool in fair use cases. Here I speak of amicus briefs. Litigators must consider when to solicit amici in cases where their client is a party. When doing so, it adds something useful to the discussion. Moreover, as a practical matter, parties may not have space in their briefs to fully explore every possible issue. And while we perhaps think of amicus briefs most prominently at the Supreme Court, there's plenty of room down here, there can be a role for amici at all stages of a case, including district court proceedings, where they can assist the litigators in shaping the issues early on. Note, however, that different procedures apply to amicus briefs at different levels. At the district court, for example, you need leave of court to submit one. For example, as I will discuss more later, Fox News versus TV Eyes was a single plaintiff fair use case that we litigated on behalf of Fox. It involved the reproduction of television news content that the other side argued assisted with media monitoring and was thus fair use. As the case raised important issues to other news organizations as well, we encouraged them to share their views with the district court by seeking leave to file an amicus brief then at the time of summary judgment briefing. Judge Hellerstein granted leave, and the resulting briefing helped frame the effect on the market issues. In addition, when your client isn't a party to a case, they can still have their voice heard as an amicus. As an example of this, let's turn to Cariou, and I know there's a lot of people in this room who are involved in that case, and how amicus briefs played a role. Cariou asked whether it was fair use for appropriation artist Richard Prince and the gallery that exhibited his works to use photographer Patrick Cariou's photographs of Rastafarians as part of a series of paintings and collages. On behalf of our clients, the American Society of Media Photographers and the Picture Archive Council of America, we filed an amicus brief arguing that an overbroad conception of transformative use would destroy the original author's exclusive rights, including the right to prepare derivative works. We wrote that it is clear as a matter of statutory construction that merely because a work is transformed in a second author's work does not make that second work of fair use. To hold otherwise would put Section 107 in conflict with and potentially nullify the copyright's express grant to copyright owners of the exclusive right to prepare derivative works, which by definition involve transformation. But the role of an amici is not just to point out problems, rather it's better to offer solutions. Thus, we argued that the derivative work's transformative use tension could be resolved by ensuring the use in some way related back to the original work. Specifically, you wrote, it is this necessary relationship between the original work and the new work that can justify the taking of the original without permission or compensation. Counsel for Prince and his co-defendants in their reply brief specifically cited both counsel for Cariou's argument on this score, as well as our amicus brief to challenge this relation back idea. In finding that 25 of the 30 Prince works at issue was fair use as a matter of law, the Second Circuit rejected this relation-backed principle and adopted a broad view of transformative use. Carrier, however, was not the end of the debate between the derivative work right and transformative use. Famously, just a year later in Scotty Nation, Judge Easterbrook, writing for the Seventh Circuit, expressly criticized Carrier, and in particular, its over-reliance on transformativeness at the expense of the statutory factors. Moreover, the court stated that in the Seventh Circuit's view, Carrier and its predecessors in the Second Circuit do not explain how every transformative use can be fair use without extinguishing the author's derivative work right. By the time Warhol v. Goldsmith, and I know there's a lot of hands in this room involved in that too, reached the Supreme Court last year on the meaning of transformativeness under Factor 1, the issue had been debated in the bar, in law reviews, and before the courts. A deluge of amicus briefs from a wide assortment of stakeholders were submitted to the Supreme Court on the derivative works issue alone, including one our team filed on behalf of the Association of American Publishers. At issue in Warhol was the Andy Warhol's Foundation commercial licensing of a silkscreen portrait by the acclaimed artist Andy Warhol that had been made based on a photograph by another acclaimed artist, photographer Lynn Goldsmith. In a majority opinion by Justice Sotomayor, the Supreme Court held that transformativeness is a matter of degree that requires a proponent of fair use to justify the copying. Important to our discussion today, the court emphasized the need to protect the derivative work right and that an overbroad concept of transformative use that includes any further purpose would narrow the copyright owner's exclusive right to create derivative works. Thus, the court held the degree of transformation required to make transformative use of an original must go beyond that required to qualify as a derivative, and that simply to convey a new meaning or message does not suffice. After finding the use in issue not transformative, the court affirmed the Second Circuit's finding of no fair use. This little bit of legal history is just one example to show how litigators and their clients can shed light on issues, contribute to a larger debate, and incrementally shape the law, which in this case resulted in the Supreme Court addressing the very issue we and many others highlighted so long ago. While sometimes the law can change instantly, very often it's more of a marathon than a sprint, with many constituencies helping to advance the law, including litigators and their clients. Okay, let's turn to the next tool as a litigator, marshaling the facts. I've been teaching a course on copyright and trademark litigation at Harvard Law School for about 15 years. On the first day of every semester, I tell the class, the facts are not a given. Don't worry. By that I mean that while facts and judicial opinions look comprehensive and compelling, they only get to the court's attention if lawyers find them and try to get them in the record. Developing the factual record is a unique contribution of litigators in a case. Lawyers need to figure out which facts might be relevant and then use appropriate discovery methods to ferret them out. Traditional tools, such as requests for production of documents, requests for admission, interrogatories, and depositions, should of course be used. But a litigator sometimes needs to be a bit more creative about how to find facts. For example, when we were doing discovery on the copyright part of the J-Star case, we needed to establish what Eisenhower's state of mind was in 1948 as to whether the book Crusade in Europe was written as a work for hire at the instance and expense of publisher Doubleday. It was challenging, as all the recipient witnesses were dead. We thus had to scour the archives of universities across the country, including, thank goodness, helpfully, at Columbia. Who knew that Eisenhower had been president of Columbia? Probably Professor Ginsburg knew that. But anyway, I didn't know that until I started this case, to collect the memoirs and related documents of everyone involved. We pieced all of this together to recreate what happened at that fateful meeting between Eisenhower and Doubleday when they shook hands on the deal and Eisenhower agreed to write the book. In fact, in my closing argument, I kind of acted out the various roles using the dialogue contained in the various memoirs. We won the bench trial, a permanent injunction, and attorney's fees, and the Ninth Circuit affirmed. Although in this case, we did the factual work ourselves, a litigator may also want to employ private investigators in certain cases. Now, in creating your discovery plan, remember that context is key. Pretend for a minute that you're litigating a car accident case. I know, hard to believe, but pretend for a minute that you're litigating a car accident case where your client ran a red light and crashed into a parked car. At first glance, the facts don't look so good for your client. But if you discovered that the only reason why your client ran the light was to avoid a kindergarten class that had darted into the street, it's easy to see that this might be helpful to the defense. The importance of context is particularly true in fair use cases where the facts are so important. The first and fourth fair use factors are particularly fact-rich, as we need to assess the claim justification for the use, consider whether and to what degree it's substitutive, and whether there's harm to existing or potential markets. While the parties themselves may have much of this information and the relevant documents, a litigator must also think about non-party sources of information, which can be especially probative as to whether a market exists and whether there's harm to it. Narrowly tailored third-party subpoenas can help obtain those sorts of facts. In addition, fair use cases lend themselves to the use of creative experts, or creative use of experts, depending how you want to think about it, who can put the case in a broader context. For example, when we litigated TVIs, we contended that TVIs usurped a growing digital market for video clips of news segments. Although our client had a lot of information we needed to prove our point, we also retained a former TV producer who had become a journalism professor to position the use within a wider industry lens. She wrote a detailed report about the economic pressures facing journalism and the need to protect the ability to monetize and support journalism in new ways, like through video clips that could be licensed to third parties and or shown with pre-roll ads on websites. And as I will discuss more later, we won the case on summary judgment and then won affirmance in the Second Circuit. Of course, in any given case, there may be one or more bad facts from your client's perspective. Rarely with my clients, but you know, it can happen. As a creative lawyer, however, you can sometimes change the facts prospectively, and let me emphasize the word prospectively, or at least shed light on their context and not treat them as forever static. When I talk to my team about this, I cite the important precedent of Kobayashi Maru. No, Professor Ginsburg, this is not a Supreme Court case that you somehow missed, though I know you've memorized them all, but something, or if not, Professor Fromer has, but something from Star Trek. First introduced in Wrath of Khan, the Kobayashi Maru was a simulation test for Starfleet Academy that was programmed to always result in failure. It was impossible for cadets to rescue the Kobayashi Maru without destroying their own ship. Young Captain Kirk, however, rejected the idea of a no-win scenario. He reprogrammed the simulation to provide an opportunity to win, and for the first time in Starfleet Academy history, the ship was saved. I think this is a helpful mindset for litigators. As although you cannot change the past, and I'm certainly not advocating associates here at Kirkland hacking into computers. Yes, this, you too, former associates, no hacking. I am certain you can possibly change things to improve your client's position going forward. This can involve many things depending on the case, including prospectively changing a website's terms of use, taking down allegedly infringing content, and thereby potentially minimizing damages, adding a disclaimer, finding a new source for a product, and or redesigning a product where feasible so that the impact of that case is cabined in. Sometimes the new thing might be a PR campaign or something like that. Again, you can only change future conduct. Sadly, however, sometimes people try to change the past, and you need to be alert in all seriousness for that possibility. In other words, it's important to take a critical eye and not accept everything produced in discovery at face value, especially in this digital age where fabrication is incredibly easy. An illustration of this concern, consider our Obama Hope poster case. There we represented the Associated Press news organization against artist Shepard Fairey and argued that Mr. Fairey had engaged in copyright infringement by using, without a license, an AP photograph made by its photographer, Manny Garcia, as the basis for the Obama Hope poster. The poster became a fixture of President Obama's first presidential campaign and various merchandise. The AP sent a cease and desist letter protesting use of the photograph without a license and noted that if a license could not be negotiated, it would commence a lawsuit in the Southern District of New York the following week. The day before that deadline, with a 16-page press release, Mr. Fairey elected to file suit in the same court for declaratory judgment of non-infringement. In his declaratory judgment complaint, Mr. Fairey alleged that contrary to the AP's claim that he used a particular portrait photo by Mr. Garcia of then Senator Obama, that he had instead used a different photograph from the same news conference on the crisis in Darfur, also made by Mr. Garcia, but what included both Senator Obama and actor George Clooney. Discovery ensued, including as to which photograph was used. Mr. Fairey produced in discovery a digitized image file allegedly showing how he had modified the Clooney photograph to get to the poster. All of this struck us as odd. It just didn't seem credible that someone would have contorted a photograph to get the image that became the poster when another photograph appeared to be a perfect match without any complicated digital editing. It also seemed a little bit convenient from a fair use perspective, as if the Clooney photograph had been the one used, perhaps Mr. Fairey would say that he had transformed it more under factor 1 to make the poster, and that he used less of it under factor 3. One thing copyright litigators do, especially in photography cases like this one, is to overlay images to show how they compare. And that's what we did here. As you can see, the Obama image in the Clooney photo does not line up with the poster. By contrast, as you can see, the Garcia portrait photo that the AP claimed had been used lined up perfectly. Yeah, you kind of laughed. That's kind of what we said, too. You know, we hope that Judge Hellerstein reacted that way as well, but whatever. We thus studied the digital metadata for the poster and the photograph and discovered that the metadata file paths did not support Mr. Fairey's story about how he created the poster. The metadata also indicated, for example, that there were more responsive documents on Mr. Fairey's computer than he had produced. We confronted Mr. Fairey's lawyers with this evidence, and they admitted in a memorable Friday night letter that Claudia Ray, I know, remembers, that the correct photograph was indeed the Manny Garcia portrait photo that the AP had asserted all along. They also admitted that the image of Mr. Fairey had provided in discovery had been fabricated, and that other evidence had been deleted by Mr. Fairey rather than produced. Finally, they said that they were planning to withdraw from the case. Ultimately, Mr. Fairey was indicted by the U.S. Attorney's Office on obstruction of justice a charge to which he pled guilty, and he later settled the civil suit with the AP. The civil suit against Mr. Ferry's apparel company and declaratory judgment co-plaintiff, Obey Clothing, continued, however. The AP ultimately won summary judgment, striking the fair use defense, and then the case ultimately settled as well. Now, I wish I could say that this was the only case we've ever had where fabricated evidence was at issue, but unfortunately, it wasn't. In fact, possible fabrication was on our minds in Ferry because we encountered a similar issue just a few years earlier in Scholastic versus Stouffer. There we filed suit for declaratory judgment that J.K. Rowling's acclaimed Harry Potter books did not infringe Stouffer's alleged trademarks and copyrights, including in the term muggles and in the books Larry Potter and his best friend Lily and the Legend of Ron the Muggles. Stouffer claimed the books had been printed in the 1980s. It looked new to us, however, and trusting our instincts, we hired a typeface expert to conclusively determine that at least part of the text could not have been printed in the 1980s, as the typeface technology didn't exist until the 1990s. This led to a wholesale review of other documents produced in discovery, including sending a paralegal to the archives of a magazine so we could compare ads as they had been produced in discovery to how they actually ran. We discovered some had been altered by adding the phrase, trademark muggles. We successfully moved for sanctions with respect to 7 different types of fabricated evidence, as well as summary judgment on the merits. With today's AI tools, vigilance as to what has been produced is more important than ever. In sum, it's the litigator's job to determine what facts are needed to tell the client's story of fair use or unfair use, and then develop the record using both fact and expert discovery creatively, but not too creatively. All right. We've now discussed the litigator's role in helping to shape the law and in discovering the relevant facts of each case. So let's now discuss how a litigator brings the law and facts together to persuade the court and jury. This is where the magic happens. Litigation is the art of persuasion. And as a former theater person, I can tell you, it's not a joke, no surprise, right? As a former theater person, I can tell you that litigating is a lot like putting on a show, a nonfiction show, especially at trial. There's plenty of seats down here if need be. It's vital for a litigator to synthesize the facts and the law to develop an easy-to-understand and convincing theme. Fair use may be a complex doctrine, but if you start your presentation with, "This is complicated," you're likely to lose. Rather, you need to simplify and persuade, whether at a brief, an oral argument, or a trial. Consider our TVI's case. In its briefing and at oral argument, TVI's relied heavily on the Google Books case, in which the Second Circuit had held it was fair use for Google to copy entire books and reproduce snippets of them in response to their queries. Central to the holding in that case, however, was that Google Books was designed to reproduce only snippets of the copied books. As Judge Chin wrote on summary judgment in the district court, Google Books provides a new and efficient way for readers and researchers to find books. On appeal at the Second Circuit, Judge Laval noted that even if someone set out to do multiple searches of a particular book, the resulting aggregation of snippets would be incomplete, which made substitution unlikely. The Second Circuit also noted that Google Books prevented someone from getting a complete book by blacklisting one snippet on each page and one complete page out of 10. Key to the Google Books holding, therefore, was that you could not get the whole text of any of the copied books. By contrast, we argue TVI's was substitutive because it made all television news content available to users in as many 10-minute segments as they wished, without any of the blacklisting design elements of Google Books. TVI's even advertised that subscribers could further download and save the clips and further distribute the clips by email and using them on social media. All of this, we contended, posed an existential threat to the market for television journalism. To make all this clear, I came up with a theme that distinguished Google Books head-on. We argued that whereas Google Books was a program designed to find content, TVI's delivered content. This finding versus delivering theme guided us through our discovery efforts, our briefing, and our oral arguments. For example, at oral argument before the Second Circuit, after appellate's counsel argued that TVI's was simply Google Books for television, I argued that TVI's can be decided by recognizing the fundamental difference between services that find copyrighted works and those that deliver copies of such works. While this court has held in other contexts that search can be a quintessential transformative use, well, so too should delivery of content be quintessential infringement. The Second Circuit agreed, recognizing that we were not challenging search, but rather redistribution of the audiovisual content. In an opinion by Judge Jacobs, the Second Circuit thus affirmed that the TVI service was not a fair use and was more akin to Kirkwood and other retransmission cases than Google Books because the content was redistributed. Notably, a different Second Circuit panel in the Redigi case, a little bit later that year, discussed TVIs as well. Redigi asked whether a service that allowed users to resell their digital music files was unauthorized distribution or a fair use. In an opinion written by Judge Laval, the Second Circuit endorsed the fair use decision in TVIs, writing that TVIs was a substantial precedent for the Second Circuit's finding of no fair use in Redigi, and that the modest transformative purpose in TVIs was easily outweighed by the harm to the rights holders' market. Now, switching gears a little, another point about oral argument in particular is that part of the persuasion process is respectfully attempting to teach a court to see the case from your point of view. My mom was a teacher. My sister who's here today is a teacher. My daughter, Lucy, is going to Columbia Teachers College. My son is at 3L at Fordham. And my husband and I met in Harvard Law School. So there you go. Anyway. But other people here's moms were teachers too. And this particular epiphany was brought home to me by the foreword written by Justice Ruth Bader Ginsburg to a book on Supreme Court arguments, which I eagerly read before I argued Daystar before the court. In addition to making a lot of helpful points about oral argument in general, Justice Ginsburg likened arguing in court to her experience as a teacher. As she reflected on her first Supreme Court argument, Justice Ginsburg wrote that a teacher by trade, I relished the opportunity to persuade them that my cause was just, my legal argument sound. She saw oral argument as an opportunity to teach, not an ordeal to resent. I found this idea of teaching an opportunity to be a useful way of approaching oral argument. To illustrate the point about using oral argument to teach and convey your theme, I think it's useful to consider briefly the Rentmeester case. There, a photographer alleged that Nike had infringed his copyright in a photograph of Michael Jordan leaping when Nike made its own iconic photo of Mr. Jordan that led to its Jumpman logo. When I teach this case in my law school class, I start by polling my students, many of whom have never taken a copyright class before, to see who thinks the two images are substantially similar. At first, many hands go up. Then I teach the idea expression dichotomy and ask again. This time, fewer hands. Finally, I start pointing out all the differences in expression, the color, the proximity to the hoop, the bend of the arms, and the difference between a more traditional grand jeté, scissor-type split, and a straddle-style jump. When I ask again if the images are substantially similar, few hands go up. And then when I tell them I represented Nike in the case, no hands go up. It is blind grading, right? Allie is one of my former students who's now at Kirkland. Allie Cunningham can attest, all right. My actual oral argument in that case on our motion to dismiss for lack of substantial similarity used the same principles. First, I used the theme that no one can own the idea of Michael Jordan jumping in a pose inspired by a grand jeté. Second, I emphasized the various expressive differences. I even acted out as best I could the difference between a scissor-style horizontal split, as in the Rentmeester photo, and the vertical straddle-style jump in the Nike photo. The Ninth Circuit affirmed the district court's grant of our motion to dismiss, and the lesson here is that persuasion is closely tied to teaching. All right, now let's turn from oral argument to trials, specifically fair use trials, which may be the ultimate theater for a fair use litigator. Having a theme at trial is absolutely critical. Not only will the theme help you persuade the court or jury, but it also provides a compass for you to keep your presentation of evidence on track and help the fact finder see how disparate pieces of evidence and testimony fit together. I know that Professor Ginsburg has always appreciated the theme we used in the Harry Potter lexicon case, so I think it makes sense for me to return to it now. The Harry Potter lexicon case concerned whether a so-called Harry Potter encyclopedia was fair use. Well before the case was ever filed, there had been a free fan-made website called the Harry Potter Lexicon that compiled and analyzed many aspects of the Harry Potter books for other fans. One part of the website contained an alphabetical list of the people, places, and things in the Harry Potter universe. After Ms. Rowling announced her intention to write her own encyclopedia after she completed the last of the 7 Harry Potter books, publisher RDR Books contracted with the editor of the Lexicon website, Stephen Vander Ark, to rush out a book of just the A to Z listings from the Lexicon website. That is not the essays or other analyses, as an unofficial Harry Potter encyclopedia. After cease and desist letters were unsuccessful, J.K. Rowling and the Harry Potter Books film studio, Warner Brothers, filed suit in the Southern District of New York and sought a TRO and preliminary injunction against the publication of the Harry Potter lexicon book. In our complaint and subsequent motions, we contended that unlike a true encyclopedia, the lexicon book merely repackaged the Harry Potter series, as well as the companion books to it, Quidditch Through the Ages and Fantastic Beasts and Where to Find Them, with little or no analysis, research, or even quotation marks. RDR's defense was fair use. Judge Patterson combined the preliminary injunction hearing with a bench trial on the merits. And we were off to the races in a trial that created a media frenzy of cameras on the courthouse steps and so much public interest that after the courtroom filled up, the courthouse staff set up an overflow courtroom for people to watch the trial unfold on closed-circuit television. It was clear that for a lot of reasons, I needed to come up with a concise, convincing trial theme that would show how each of the fair use factors favored us. It needed to get to the heart of the argument that this was not a true encyclopedia and that the copying was overly extensive in a way that would persuade the court. I didn't think that merely saying the 4 fair use factors favor us would be that persuasive. Rather, our theme was that the lexicon takes too much and does too little to be fair use. With that phrasing, I wanted to emphasize the wholesale copying and the little, if any, transformative value of the so-called encyclopedia. The point was that the lexicon added little, if anything, beyond Ms. Rowling's own words. There was no commentary, no analysis. It had only sporadic and often inaccurate etymology, and none of the other things you would expect in an encyclopedia. As the lexicon's first page even noted, all the information in the Harry Potter lexicon comes from J.K. Rowling. And this is exactly what we wanted to convey, that it was all Rowling's work. But it isn't enough to just have a theme. A trial lawyer needs to use it. The takes too much and too little theme was therefore an important framework for presenting the evidence and bringing out key factual points. Starting from my opening statement and continuing to the closings, we returned again and again to the massive verbatim copying and lack of analysis or other creative additions, as well as to the highly imaginative world of J.K. Rowling and the need to protect it. Part of defendants' argument was that Ms. Rowling and Warner Brothers were engaging in copyright misuse or the enforcement of copyright beyond the law's reasonable bounds. In some ways, however, this gave us an opportunity to show that neither Ms. Rowling nor Warner Brothers objected to two true reference books that took less of Ms. Rowling's expressive universe and did more with it. We showed that many books fit this theme and thereby showed what made the lexicon different. We did this in part through a series of slides that I used in my opening. I explained that the evidence would show that there are books about Harry Potter and religion, that there are books about Harry Potter and literature, that there are books about Harry Potter and children, that there are books about Harry Potter and science, that there are books about Harry Potter and business management. You tell that to Columbia Business School, okay. There are books that parody Harry Potter. There are even other guides to Harry Potter. But as I told the court, these books, Your Honor, took less and did more. In her testimony, Ms. Rowling also emphasized how the lexicon took too much and did too little. She testified that the lexicon took all the highlights of her work, or as she analogized it, the lexicon took all the plums in her cake. It's hard for me to talk about this, seeing Melanie Bradley, now by another name, who helped me work on this case back in the day, along with Claudia Ray and many others, but anyway. Anyway, she also explained how the lexicon didn't add enough to justify the taking. Ms. Rowling testified that if Van der Ark put quotation marks around everything he had lifted from her book, there would pretty much be quotation marks around the whole substance of the book with a few sides omitted. That is to say, the lexicon took too much and did too little. She used the theme in explaining market harm, too, noting that if it became legally acceptable to take an extreme amount of an author's work and add little to it, the floodgates would open. Finally, she described the devastating injury to her as an author in having her words retaken and resold under a different author's name. Similarly, when I questioned Mr. Van der Ark, I tried to emphasize our takes too much, does too little theme, and use it to understand the evidence. As shown by the example on the screen, I asked him what the Chudley canons were. I know, you know what that is, Jordan, but anyway. And as I expected, he gave a short answer, namely, it's a Quidditch team. I then juxtaposed that short answer with an exhibit from the text of the lexicon, showing that he included far more than that short response in the lexicon. Rather, he put in an extensive description, which was virtually identical to the text Ms. Rowling herself had written about the Chudley canons. I then got him to admit that these were fictitious facts, hearkening back to the Seinfeld aptitude case, and that they were Ms. Rowling's creative output. Finally, I got him to confirm that he took everything. As he admitted, it looks like we pretty much caught it all. I will also add that when part of your point in arguing factor 2 is the tremendous creativity of your client's work, it's important to bring that out. Don't hide it under a bushel. So, and this can happen in many ways throughout a trial. For example, my opponent made a big show of introducing his client as the man about whom none of us would be here, Roger Rappaport of RDR Books. I felt that statement could not go unchallenged. Immediately after he said this, when I stood to begin my opening statement, and I am standing now, by the way, I emphasized that the person without none of us would be here is J.K. Rowling. I wanted to set the right tone from the beginning. Her works were important. Similarly, at the end of my opening, perhaps at the risk of being a little theatrical, it's hard for me to believe, I dove into the copyrighted work and used it to re-emphasize our theme. As I said, in closing, it seems right to go back to Ms. Rowling's words. At the end of Harry Potter and the Goblet of Fire, Professor Dumbledore, headmaster of Hogwarts, cautions the students that there may come a time when they must choose between what is right and what is easy. We submit, Your Honor, that by taking too much and doing too little, RDR chose to do what was easy, but the evidence and controlling law of this circuit show that it wasn't right. Ultimately, the court held the lexicon was infringing and was not fair use. The court found that while it was slightly transformative, this was not enough to justify the wholesale copying without even quotation marks. In other words, the court found the lexicon took too much and did too little. Note that the court found no fair use, even though it found the lexicon was slightly transformative. This was also the situation in our TVI's case, where the Second Circuit said the service's modest transformative character was not enough to justify its copying. It's interesting to me, reflecting back on these cases, that both the Harry Potter lexicon and TVI's courts found fair use despite findings that the uses were slightly or modestly transformative. This seemed right to me, as I never understood why a finding of transformativeness should be an outcome determinative litmus test, given the express direction in Section 107, the courts shall consider at least the 4 factors, none of which perfectly corresponds to transformativeness. This I appreciated Justice Sotomayor's majority opinion in the Warhol case, repeatedly emphasized that transformativeness is a matter of degree, and it must be considered along with the other factors. I was also heartened by the Warhol case. In so many ways, it seemed to be a validation of our Obama Hope poster case that, among many other people here, Claudia Ray, Josh Simmons, and I litigated, including by vindicating the idea that fair use cases often involve not 1, but 2 artists. Both cases involve photographs used as artist references to create new images. The other thing that struck me about both cases, about how in both cases the side claiming fair use argued that the reference photo was not very original and entitled to much protection. In Warhol, the foundation argued Goldsmith was attempting to copyright Prince's face. Opposing counsel made almost the identical argument in the Ferry case. But whereas the other side in the Hope poster case tried to minimize Mr. Garcia's artistry, we used our powers of persuasion to try to elevate it. For example, we adopted the language photographers use to describe their work. Photographers don't talk about taking a picture, they speak of making one, as that emphasizes their creative process as opposed to simply happening on a picture and picking it up, as taking seems to denote. Part of our case, therefore, involves showing how Mr. Garcia made a patriotic portrait of the then junior senator from Illinois, Barack Obama. For example, we included in our filings how Mr. Garcia had liked the patriotic flag image behind Senator Obama, how he chose the right filter and moment to make the photograph, and how he even got on his knees to get the angle just right for making the portrait photograph he wanted. In thinking about persuasion, lawyers need to be careful to make sure their arguments are consistent with the facts. While the Ferry side tried to argue there wasn't anything special about the Garcia headshot he used, that was not what Shepard Fairey had said, both in a newspaper interview he gave prior to the lawsuit and in his deposition, where he said he selected the photo because of its special qualities. It's important, litigators, go look and see what people say in newspaper articles before you depose them. As Mr. Fairey testified in his deposition, there are a lot of different historic photos of people like John F. Kennedy and the famous Corda Che Guevara photo that has this feeling of the subject knowing what lies in the future, of having some sort of wisdom. And it's a specific angle of the gaze that was really what struck me about the photo. In other words, it wasn't unimportant to Fairey. We further tried to persuade the court on this issue by using some of the images that Mr. Fairey had downloaded and rejected as references to make the poster that were not originally produced. As he testified in his deposition, none of these outtakes were as good as the AP photo that was the subject of the lawsuit, as they made Senator Obama look grumpy or unsure, or they had a giant hand. This evidence helped to highlight the creativity of the AP's photograph and to rebut the argument to the contrary. The bottom line is that litigators are in a unique position, sometimes incrementally, sometimes more dramatically, to impact the law and achieve results for their clients. Doing so effectively requires a suite of tools, starting with command of the case law, the ability to identify and harness facts creatively, and ultimately, the ability to persuade. Okay, let me now look briefly to the future and ask, what does all this mean about the future of litigating fair use? I've discussed how Warhol fits into the story of fair use, but what about Google v. Oracle? Where does the Supreme Court's other recent fair use case fit into the past and future of fair use? We served as co-counsel to Oracle in the appeals before the Federal Circuit and the Supreme Court, and I'm looking at my partner Josh Simmons in particular about this. The Supreme Court ended up upholding a jury verdict that Google's use of Oracle's Java code to develop the Android platform was fair use. I want to make a few brief points. First, I'm concerned the courts may be viewing Google as encouraging jury trials to decide fair use, when I don't think that was the Supreme Court's intent or indeed what the court held when it decided that Google's use was a fair use as a matter of law. This interpretation is buttressed by the Supreme Court's affirmance of the Second Circuit's holding of no fair use as a matter of law in Warhol in a summary judgment case. The Google case was an appeal from a jury trial on fair use, yes, and that meant the court had to grapple with the standard of review in the context where fair use is a mixed question of law and fact. The court, however, did not endorse the idea that fair use always must go to the jury. Rather, the court endorsed the Federal Circuit's conclusion that although fair use involves subsidiary historical facts that may be decided by a jury, the ultimate question of whether a use is fair is a legal question for courts to decide. In his majority opinion, Justice Breyer acknowledged this interpretation and wrote that fair use primarily involves legal work. So although Google v. Oracle involved a jury verdict on fair use, I don't think it can be read as requiring a jury verdict on fair use. In fact, as Oracle noted in its Supreme Court brief, the historical record of fair use trials is sparse. Rather, courts most frequently address fair use as a matter of law on summary judgment. In light of this, it's interesting to me that post-Google, it seems that there are more judges denying summary judgment and finding factual disputes that must go to the jury. Often, of course, this is the right call, as it's the jury's role to decide material and genuine factual disputes given the important Seventh Amendment right to trial by jury. But with fair use, many disputes are not really about the facts. Rather, they are about the legal interpretation of known facts. And even if there were a factual dispute about something, not all factual disputes might materially affect the court's ultimate balancing of the fair use factors. As I think you can tell, I love trying cases. But I think it's also right to admit that jury trials can be expensive and burdensome for both the parties and the court. How many in-house counsel here would prefer not having to pay for jury trials, right? Exactly. Thus, I think it's an issue to watch. Second, the Google court's decision to start with factor 2, the nature of the work, and champion it as a key factor in deciding fair use in software cases is well known. Another issue to watch is whether we will see other creative applications for factor 2. For example, we're litigating a series of cases that ask whether it's fair use to depict athletes realistically in a video game with their tattoos based on licenses from the athletes to use their likenesses, or whether permission from the athletes' tattooists are also needed to include the tattoos. We won the first of these cases, Solid Oak, on summary judgment in the Southern District of New York on 3 grounds: implied license, de minimis use, and fair use, in a decision by Judge Swain. The nature of the work is particularly interesting to me in this context. Tattoos are permanently inked on human beings who have their own rights and freedoms separate from that of the copyright owner. Tattoos inked on a person's body thereby seem inherently different in nature from a painting on a canvas or a manuscript on a piece of paper, both of which are detached from the human body. You couldn't show people as they actually look without showing their tattoos. How should factor 2's analysis apply in a context like this? Other situations may also arise where the nature of the work may prove particularly significant. Gone, I think, are the days when factor 2 was reduced to whether the work was published and whether it was factual or creative. Third, there's the little question, you know what I'm going to say, right, gang, of how fair use, will be applied to AI. Answering AI questions seems to have become the full-time employment of the copyright bar, right? Do I hear you, gang? Right? Exactly. I see many people in this room litigating a lot of these headline cases. I wish I could tell you which way the myriad courts considering this issue will decide the many cases currently being litigated, but I cannot. This is especially true if many cases are decided via jury trials instead of through summary judgment decisions, where it's sometimes easier to see what drove the conclusion. As we know, fair use requires a case-by-case analysis such that outcomes may differ based on the facts and the context. Where the works involved and where the uses of them differ, the fair use factors might produce different outcomes. In other words, we might not end up in a one-size-fits-all answer to the various questions on AI and fair use. As we work through these AI issues, the ability of all the actors in the copyright system to bring their expertise to the table is going to be very important. I have one final thing to say about litigating fair use, and that is, you don't do it alone. One of the things about litigating cases is that you work as a team with your partners, associates, and clients, and often your colleagues in the bar as amici, and sometimes law professors who kindly send you their most recent article that you disagree with. If you like this lecture, please come in as an amicus for me once on one of my cases. But anyway, everyone is part of the process, and the result is the product of teamwork. I'm very proud that many Kirkland colleagues, past and present, as well as many clients and friends in the bar, sometimes both, are here tonight, because this work was done and is being done with all of you. In particular, I would like to call out my partners, Claudia Ray, Joshua Simmons, and Shanti Conway, who were key members of many of the case teams whose work I have discussed tonight. as well as Josh Berlowitz, Columbia Law School, class of 2023, and now an associate at Kirkland before he leaves to a clerkship with Judge Jacobs, who helped me prepare the Manges lecture tonight. The bottom line is that we are all lucky to be part of the diverse and passionate copyright community, and it's exciting to think about how each and every person in this room or watching later online will help further shape the law. Thank you. Now that really takes me back to my old theater days, except as my friend Lenore Skenazy from Yale, who's recently, and my friend Dinny from Yale, who was recently in the New York Times this past Sunday, knows I was usually in the chorus as the non-dancing penguin in illegal productions of Mary Poppins. But there you go. I understand there are a few questions that people want to
Yeah.
for.
The questions could be
Upstairs?
put to you upstairs.
Okay.
The reception will be in the Case Lounge, which is on the 7th floor. So when you get out of the elevator on the 7th floor, take a left, and look forward to seeing all of you up there.
Meet you up there. Thank you.